We will go on the record in the matter 24 CT 17, 24 TR 60 and 61. State of Wisconsin versus Natasha Mansfield. The state appears through District Attorney Kevin Schmidt in person. Ms. Mansfield appears in person with counsel Nicholas Davis. We're set today in this matter for a plea and sentencing. The parties have reached an agreement. Mr. Davis, please recite it for the record.
Your Honor, my client is going to be pleading guilty to an OWI third, and we really never knocked it out of what the agreement was going to be, so I think it's just going to be free to argue on that. And the only thing I can tell you is my client did successfully complete the IDIP program.
All right, thank you.
And the fine and cost will be what the district attorney tells me they are.
WI third and BAC is 0.227. So unless something else was agreed upon, IDIP guidelines would say it would be $3,175.
And I do see in the file that in August of 24, former DA Renicky agreed that she did the IDIP. We do the IDIP guidelines.
All right. And so then the guidelines would be that amount in fines and fees plus a $10 blood draw fee, 55 days of jail, 24 months ignition, interlock, and revocation, 125 hours of community service, or the ability to convert that to additional jail days.
Yes, I was going to argue for the 45 days, but I believe she's already lined up the monitoring with Terry. Tessa. So we're not going to argue against that.
All right. Okay. So I have in front of me the plea questionnaire waiver of rights form, and you recognize this document?
Yes.
Did your attorney go over this document with you?
Yes.
Did he go over it thoroughly with you? That is essentially word for word.
Yes.
And you understand everything completely.
Yes.
If by chance you didn't understand something, did you ask him to thoroughly explain it to you?
Yes, I did.
And he did so.
Yes.
Is that your signature on the second page?
Yes.
You're pleading guilty to one count of OWI, operating while intoxicated, third offense. Is that correct?
Yes.
You're 42 years old. You have 12 years of schooling. You can read, write. You understand the English language. Is that correct?
I am 43.
What did I say? What did I say?
42.
Oh, I'm sorry. I just read it wrong. It's a cute little 3 that looked like a 2. So you're 43 years old. All right. Did your attorney go over with you the mandatory minimums as well as the maximum possible penalties you face?
Yes.
And he went over with you what the state would need to prove your guilt?
Yes.
No alcohol, no drugs, no mental illnesses or disorders, correct?
I do suffer from depression, so I do have medication for that.
But you do take that as prescribed?
Yes, I
Did you
do.
take it today?
Yes, I do.
Oh, all right. So
Does it interfere with your ability to comprehend or understand things?
No.
Does it put you in a better disposition?
Yes.
Okay. And because you're charged with crimes, you are entitled to constitutional rights, and each of these rights is listed on this document. And your attorney thoroughly went over those with you?
Mhm.
Is that a yes?
Yes.
And do you understand them completely?
Yes.
Do you need me to go over those rights with you in any more detail? Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand the state would have to prove on or around January 7th, 2024 in Burnett County, Wisconsin, you operated a motor vehicle while under the influence of an intoxicant, which would be a misdemeanor, and this shall be counted as your third offense. Do you understand what the state would need to prove?
Yes.
Do you understand the maximum and minimum possible penalties? You could be fined not less than $600, but no more than $2,000, or imprisoned for not less than 45 days, but no more than 1 year in the county jail. Do you understand that?
Yes.
Do you also understand that upon conviction, the court shall revoke your operating privileges for not less than 2 years, but no more than 3 years, and shall order you to submit to an AODA OWI assessment and follow through? Do you understand that?
Yes.
Do you understand that here you completed the IDIP program, the Intoxicated Driver Intervention Program, and that by doing so, you have the ability through the agreement and recommendation to the court to follow those guidelines? Do you understand I'm not bound to follow that recommendation?
Yes.
Said differently, I could sentence you if I thought this was a more serious matter, all the way to the maximum possible penalties. You understand that?
Yes,
Do you still wish to proceed and enter a guilty plea?
yes,
Did you go over the criminal complaint with your attorney?
yes,
In particular, that section where it's called a probable cause section, where it basically says what happened that day and why you were charged with the crimes?
yes,
And for the record, you are currently looking on the electronic version on your attorney's laptop, correct?
yes,
And for the most part, are those facts accurate?
yes,
Are you admitting here today that you in fact did operate a motor vehicle while under the influence of an intoxicant?
yes, I did.
And this would be your third countable offense.
Yes,
Mr. Davis, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor, there was an expired registration of the vehicle. There was a valid stop. And upon the officer's observations, my client was arrested for OWI. There was a blood test, and I believe it was above a .08, and I believe there's a factual basis for the conviction, Your Honor.
Thank you. Has anyone made any threats or any promises to you for you to plead guilty to this charge?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
yes,
and voluntarily?
yes,
Has your attorney represented you competently?
yes,
Has he answered all of your questions?
yes,
Has he looked at this matter thoroughly?
yes,
Has he looked to see if you have any defenses or possibly a lack of defenses in this case?
yes, yes,
And are you satisfied with his services?
yes,
Any questions for the court or for your attorney before I proceed?
no,
As to count one, OWI third, a misdemeanor, how do you wish to plead?
guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of OWI third. The other count will be merged and dismissed with count one. The TR matters will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Schmidt.
Thank you. We have the intoxicated driver intervention program because it incentivizes people to do what they need to do to get their license, which makes them safer drivers, and to do the driver safety plan, which encompasses AODA treatment, which also makes people safer drivers. In this case, the defendant has done those programs. As a result, the community is safer. She should be able to have the benefit of the program, which the court has already detailed in the beginning there on what exactly that is, including the electronic monitoring. I think the community is better protected for that. Given how high the BAC is, this is punishing. If she were a lower alcohol level, it could be as low as almost a third of the fines. So I think that this is appropriately punishing and in compliance with the vigorous prosecution statute. Thank you.
All righty. Mr. Davis.
Your Honor, first I'd like to make a record. I did tell Natasha, I did look to see if there was a collateral attack. Her first conviction was May 14th, 2010 in the state of Wisconsin. Obviously, everyone in this room knows that she's not entitled to an attorney, nor is that a criminal offense. Then she had an attorney, Bruce Anderson, for conviction date of January 29th, 2022 from an event stemming from September 16th of 2022. More than 10 years after the first, so that was a first offense. However, in the state of Wisconsin, anything after that, they are all countable. And that's why we are sitting here at a third offense. There are no collateral attacks with regard to her case. I'm not going to make a lazy argument that this is a misdemeanor and therefore it's not serious. It's a criminal conviction and it's been very upsetting to my client, Natasha. And it's something that has bothered her. It's been affecting her, her family, her health, and everything that's going on. So it's very serious. And it's serious. The reason the legislation makes it serious is because people die and can die when people are operating under the influence. So a very scary situation. And thank God no one got hurt. But I want to look at her character and rehabilitative needs. She took it upon herself to quit drinking, follow the conditions of bond, and go through the IDIP program. Interestingly enough, I said, when this is all finished, will you be celebrating, or what about for Christmas or holidays? And she's, no, I'm not going to drink again. My life has been better not drinking. I have a few clients that have gone down that path, and apparently it's made her life better by not using alcohol. The court's aware of her personal, what's going on with her personally. I know that we've had to push this off. Her mother, which is going through cancer, That's been a tremendous strain on my client. And also she's had to take the responsibility of her sister's son. Her sister's has some issues with drugs and addiction. And so my client is raising that child. And I'll let Natasha talk more about it, but there's a lot of consternation there. The sister's not happy with her because she thinks that Natasha's stealing her child from her, and that's just not the truth. She's assisting a child that needs help right now. My client, we're asking the court to consider this. I know there's the Huber, but her job as a homemaker right now, that if she's, I think that Tessa said that you'd have to make this order, that if she's on the home monitoring and it's allowed, that she'd be able to also drive to take the children to school back and forth and things like that. I know that's not considered a job where she's employed, but it's a part of homemaker Huber. And hopefully the court can allow her to do that. So, because she's the one that takes the children back and forth, cooks and cleans. That's her life, and it's a lot going on. And then she's dealing with this OWI. I think she's a remarkable person. Just even an OWI first can crumble people, can ruin families, ruin relationships. And if anything, it's made her stronger. She's completed the IDIP. I think she's earned the opportunity to get, and that's why I was going to argue for the 45 days jail. But she's going to be, if allowed, she'll be on the home monitoring. And again, it's only additional 10 days, and I don't think it's going to affect her life. I'd ask the court to consider this joint recommendation. She's not a threat to the public anymore. And even if she was not in here today, she's not going to be a threat to the public for driving, drinking, or anything like that. She's got a lot of responsibilities to herself and her family. And I ask the court to consider the argument. Thank you very much for your time.
Thank you. Ms. Mansfield, do you care to make a statement here today to let me know anything you want me to know?
At the time of my OWI, I was in a bad place. I lost my brother. He drank himself to death. And then dealing with my sister after that. And then now my mom. I literally don't have time to sit there and go drinking. I have too much on my plate and too much to handle, that I need a clear mind to get through all of this. So when I told him that that's not going to be a problem for me, because there's been times where my mom will call me at a drop of a hat that she needs me, and I live a mile away from her. So when I say I need a clear mind, if she calls and say I was drinking, I can't do anything for her. So I need to be there, and I need to be there for both of these kids that I'm raising. So, yeah.
I appreciate that, Ms. Mansfield. And it does sound like you have a lot on your shoulders right now. Having to live through one of those things is difficult. Having to live through all of those things one at a time, after another, and some all together at the same time is extremely difficult. I really hope that you're engaging in some type of therapy or you're doing something, because that's a lot on your shoulders.
I do have a great support system, especially my husband, and I still have medication, but every day is a new day. But yes, I do have a great support system.
That's a good outlook, and I'm glad that you have that support system, because it can get a more than a bit overwhelming. This is an OWI third, and it's serious. And I believe I've told you this before. I'm pretty certain that Mr. Davis would have discussed this with you. The next OWI 4, if you get one, it's mandatory life revocation of driver's license. No ability to argue or to say, my mom has cancer, I need to drive 2 kids around, I need to do this and that and the other. No driver's license for life, no occupational until an ability of 10 years has passed, and then you have to prove yourself that you deserve an occupational, and that's very difficult to do. So not only am I hoping and really praying that you have taken control of the alcohol demons,
Mhm.
really. That you've taken control of that in your life, but that you will never ever be in a situation where you get behind the wheel when you've had alcohol, because you will lose your license.
Yes.
It's a very scary thing, especially in our area. This could have been something more serious. As your attorney argued, it could have been an injury, it could have been a death. Heck, you could have had one of the kids with you, and it could have been far more serious. The legislature tells us that it is very serious, but you are taking responsibility. You're being accountable. You went above and beyond, and you did our IDIP program, which is not an easy course, and it makes you self-reflect, and it makes you understand what you're going through and how alcohol has played a role in your life. So you have learned a lot, and I'm really hoping that it's sticking, and it will stick, because a lot of people depend on you. Again, I stress, I understand you have a really good support system, but sometimes it's nice to speak with somebody who doesn't know you and can't say anything, and that you can just vent all the stuff.
Right.
Because life is hard. I don't see that you are a threat to the public. I don't see that the community is at risk with you. So this isn't something that would need to go beyond an argument for recommendation of the IDIP guidelines. I think the IDIP guidelines are appropriate, with the $3,175 in fines and fees, plus a $10 blood draw fee, 55 days of jail, 24 months revocation of your driver's license and ignition interlock device. You can apply for a half price one. When you leave, you can get the form, or you can do it right here, not up here, but over there with Amy once she's done here, and you can get that form and you can fill that out. You must get your ignition interlock device put on, or you won't be able to get your license back, and you can't get an occupational. So it's very important that you get that done, you get it installed, and you get that thing moving, because it sounds like you need an occupational license.
Yes.
So you can drive the kids and you can go see your mom. 125 hours of community service. You can convert that, and it would mean an additional, I think, 16 days of jail. And on monitor, it's an additional $400 that you would need to pay. The court will just assess 16 more days of jail, and then you won't have to worry about getting out and doing the 125 hours of community service. I like the community service because I think you're giving back. You can give back to Burnett County, to one of the nonprofits. You can give back to the tribe. You can do all sorts of things as long as you're not getting paid for it, and it is something that can be shown as being community service. If you decide to have it converted to jail days before your days, your 55 days are up, then it is at a $25 a day fee. But if you do it after, then it increases to 30 days or $30 a day. And so the price does go up. I have no problem with you serving on electronic monitor as like Huber with house arrest. You must sit a first 48 consecutive hours. You need to go to jail, turn yourself in, sit 48 consecutive hours. Then after that, Dave Hatch will be there to set you up on the monitor. I will permit you to drive the kids back and forth from school to practice or whatnot, but you can't go to their games. Okay? Because it is house arrest. And the holidays are coming up. So unfortunately, unless it is, I'm going to say it would need to be something that you would need to ask the court permission of, but unless it is something culturally related, like a feast or something like that, if it's just Thanksgiving at your parents' house, or sorry, at your friend's house, or if it's Christmas at other relatives' place, you can't go because this is house arrest. You can have parties at your house. I'm not saying you can't do that. But this is house arrest, and you must serve that time at home. Again, unless something comes up, then you can talk to Tessa. She'll ask the court, or she'll say you need to write a letter to the court to seek a permission to do so, all right? I will give you the authority to be able to see your mom if she needs you. But again, you're gonna have to let Tessa know right away that
Yes,
my mom
yeah,
called.
yeah.
She said that she fell down or she can't breathe or she needs her medicine, something like that. So Tessa can know to monitor you at where you're going and when. You will have the ability to go to the grocery store 1 day a week. I believe you will be put on our new monitors, which is an ankle bracelet that you can't get off. It tests your blood 24/7.
Okay.
So I would still not be around, not your blood, but it tests your sweat, the thing, your, you know, whatever it can test off of your skin, secretions. But I would not be around any rubbing alcohol with it. I don't know, these are new. It could set it off. And the court does not, I don't listen to people saying, it was rubbing alcohol or I had mouthwash or something like that. Because you can just imagine how many times I've heard people say it's this, that, and the other.
Yeah.
Okay. So I'd be very careful with it and what you're around, but I'm pretty sure that they will put on that new buddy bracelet on you. And so that's a more secure GPS and alcohol monitoring system.
Okay.
Okay. So no alcohol, you know that. You can be around somebody with alcohol. You can't consume the alcohol. Okay. You must, again, report immediately. This is an OWI third.
Yep.
When will you be able to pay your fines and fees, or do you need a payment plan?
I will need a payment plan, yes.
But you must prepay at least 30 days in advance for your monitor.
I do have that now with
Excellent.
me. Yep.
Okay, so with that, the court will order $200 a month minimum to be paid towards your fines and fees. I will say that the first payment can wait until January
Okay.
to give you a little bit of time because you're paying on the monitor. If you fail to make one payment or you don't pay at all, not only will the court enter a civil judgment against you, you could sit up to 6 months in jail for failing to pay. So it will be very important that if you can't make your $200 a month payment, that you let me know, you write me a letter and you say, I'm having a substantial financial hardship. This is what's going on. And then we'll review what's going on at that time. The court is ordering that the 24-month ignition interlock device, again, I told you about the half price and you're revoked for 24 months. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I'm ordering your DNA. You're going to need to provide that when you are at the jail. You have the ability to request it be expunged through a written letter to the Department of Justice. You can Google it. It's easy, or you can ask your attorney and he can help you and tell you how to do it. Mr. Schmidt, what am I missing?
Nothing from me.
Mr. Davis?
And she's entitled statutory good time too, correct, on the 55 days?
She would be, yes.
Yes, thank you. Nothing further, Your Honor. Thank you very much.
All right, thank you. Then we are adjourned.